Step with the black line. Face the camera. Say your full name.
Desmond Braxton.
Thank you. Mr. Braxton, you got two files with us here today. One is apparently a felony, the other one is a misdemeanor. So we'll do the misdemeanor first. You also got some traffic tickets where you missed some court dates. When you missed that court date, the judge issued an arrest warrant for you. You do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney. And if you cannot afford an attorney, the court will provide one for you. Do you understand those rights, sir?
Yes, sir.
All right. The first ticket is P1522373, charge of possession of drug paraphernalia. The other ticket is P1522376, charge of entering a vacant dwelling without owner's written permission. These are both misdemeanor charges. Maximum penalty you face on each is up to 93 days in jail and or $500 fine. I'm going to set aside the arrest warrants, enter a not guilty plea on your behalf, and give you a personal bond. Your next court date on these two matters is April the 8th for pretrial in front of Judge Yancey here in 36th District Court. Now we'll do your misdemeanor matter first. This is case 24044382, State of Michigan versus Desmond Cottrell Ernest Braxton. Counsel.
Thanks, Judge. Steve Benson for the people.
Yes, Your Honor. Brandon Bird on behalf of Desmond Braxton. My client waives his right to the formal reading, was advised his constitutional rights, and will stand mute.
Rolling a not guilty plea on your client's behalf as to bond.
Judge, I think this is where 7656A may kick in. It's a misdemeanor, but the defendant's on a personal bond on a different matter that he actually failed to appear on. The bench warrant hasn't been issued yet. I assume it will be forthwith, and he'll be before the court on that. In addition to that, he has the felony case too, Judge. That's a failure to appear. And that's what we're going to be going in front of Judge Williams about. In this particular matter, Judge, now I've been doing this long enough. I try to look a little bit deeper. Things have slowed down for me. This is a retail fraud, but what the defendant did was he didn't steal like a deodorant or some soap or something like that. He ended up stealing 78 monster cans and 32 Red Bulls. That's what he stole. And I don't know if that would be considered a necessity, even being a necessity. I mean, you're still breaking the law. But with all of that being said, Judge, we would be asking you to look at that rule, the 7656A, if that's your interpretation of it, and then just issue a bond accordingly.
It's 765.6A, is that right?
Yeah, Judge. If not, Judge, and if you don't feel comfortable, what we would be asking for is some type of monitorization. It is a misdemeanor. I'm going to be asking in the felony matter to continue the cash capias, and he already has a personal. So maybe we'll check the boxes with everything, personal, tether, and cash, like the trifecta.
So the way, here's the statute. Before granting an application for bail, a court shall require cash bond or a surety other than the applicant, which would be other than a personal bond is my interpretation. If the applicant is charged with a crime alleged to occur while on bail pursuant to a bond personally executed by him. So what was he out on when this case arose?
I believe it was, I have the case number, Judge. It was some type of theft. He was arraigned December 8th with an offense date of December 6th. He had a pre-trial February 12th that he failed to appear on. A bench warrant hasn't been issued, and he was issued a $20,000 personal.
Okay. And all right, defense?
Monster and Fago Pop, Your Honor, it's still all non-assaultive. Regardless, it is a non-assaultive allegation. 30-year-old lifelong resident, 2 children, indicates that he lives with his mother. He was forthcoming about that he does have a prior criminal history. It is misdemeanors and a pending charge right now. We're gonna ask this court for a personal bond in this matter, Your Honor.
Given counsel that the statute appears to mandate a cash bond, what would be your secondary argument?
I would really have to do some more research into that and what exactly the court means with shall. You know, it doesn't say must. It doesn't say the court must. So I'm not sure if that's a mandate or not, but I do know we
I'm
do
pretty
have
sure shall is a mandate. Pretty sure shall is a mandate.
Not sure, Jan. Not sure, Jan. I think we need a motion on that one. I think we need a motion with some case law on that one, Jan.
If there is any interpretational issues, you know, the prosecution could focus on the flight as well, because we have two cases right now where the defendants failed to appear in those two other cases. But I'll just leave it up to you guys. I have a respect for both you guys.
So the other one, we've got Judge Williams coming in on, is that correct?
Yeah, that's right, Judge.
We called Judge
Oh,
Williams,
no.
but couldn't get a hold of him, Your Honor.
And I'm sorry, Brandon. No, Judge, there are three total cases. So the felony that's up before you is different than the case that I'm using for you to qualify 7656A.
Okay. All right. Well, and there's no agreement on personal on the other case, which is why we are trying to reach Judge Williams, correct?
Correct, Your Honor.
Okay. All right. Well, we'll just deal with this one right now, and we'll let Judge Williams handle the other one. All right, Mr. Braxton, while this case is pending, you are not to go to any Dollar Tree for any reason. Is that clear, sir?
Yes, sir.
Court, reasonably think that I am mandated to set a cash bond in this matter based on the statute. Let's see. What is it? 765.6A?
That's correct, Magistrate.
All right. Court will set bond at $10 cash. What's that? Court set bond at $10 cash or surety. And counsel, are you indicating that's unaffordable?
I am, Your Honor.
One moment, please.
Sorry, Brandon. I didn't mean to throw you a curveball on this one.
No, you better believe I'm about to look up case law for it.
Yeah, for sure. Yeah. That's why I was, that's why I was throwing the flight issue as well, but I get it. Yeah.
Right. We also have an agreement with the ACLU also.
Yeah.
So, but I do want to check the what exactly are they trying to get to with that?
Yeah, we should all get on the same page on this for sure.
Yeah.
Okay. So, all right, bond redetermination date will be Wednesday, March 13. Further date will be a pretrial May 7th in front of Judge Bryant here in 36th District Court. Make sure I'm writing this down correctly.
And can I have those dates one more time, please, Your Honor?
Yeah, bond redetermination is Wednesday the 13th. Pretrial is on May the 7th in front of Judge Bryant.
And Judge, we're going to leave monitorization alone on this one.
Yeah.
Okay.
All right. Mr. Byrd, has your office reached out to Judge Williams or?
We have, but
We
we're
did this-
unable to get a hold of him, Your Honor.
All right. We'll call Mr. Braxton back if Judge Williams comes in or at the end of the docket to do the felony one.
Okay, thank you, Judge.
Yeah.
So your full name.
Desmond Cottrell, Ernest Braxton.
Thank you, sir. This will be case 24055-733, State of Michigan versus Desmond Cottrell, Ernest Braxton, and there is currently a $30,000 cash capias entered on February 24th of this year. Counsel.
Good afternoon, Judge Steve Vincent for the people, P71917.
All right, thank
Good
you.
afternoon. And good afternoon, Your Honor. Brandon Byrd on behalf of Desmond Braxton. My client waives his right to the formal reading with advice his constitutional rights, so we'll stand mute.
All right. Today is the date set for an arraignment on the warrant. Mr. Vincent Esteban.
Thanks, Judge. And I know your time is valuable, and I'm going to keep this brief. Mr. Braxton has a lot going on. He was just arraigned before you ended up showing into court on a misdemeanor case. That's the most recent case that he just picked up. He also has an ongoing case, Judge, that he was arraigned on in December. He's failed to appear on that case, and a bench warrant has not been issued, but I assume it's going to be issued forthwith. And then, Judge, we have this particular matter fit in between those two cases. This is a felony matter, and he's already capiased on this. And the
Is this the
capias,
same Dollar General in all these cases?
no, it's different stores, Judge. So, but he is traumatizing the Dollar General. The case before you today, and I was telling the magistrate, he wasn't just taking, dish soap or deodorant. He ended up taking something like over 100 cans of Monster and Red Bull. And in this particular matter, he's breaking into a place. Now, the troubling thing, Judge, is the fact that he's capiased on two matters and they're on different dates. So he commits alleged crime, and then on the first hearing date, he fails to appear. And Judge, you know as well as Mr. Byrd, Judge Childs is, he comes down with these capiases. I'm not saying keep a $30,000 cash capias, but personal bond hasn't worked. Now he's already been issued a cash bond for the misdemeanor, and we have this case. And on top of that, Judge, he has a bench warrant out of Roseville because he failed to appear after he was arraigned on a hearing date. So there's just a plethora of things going on with this defendant. And he clearly shows that he's not going to come back to court when he commits these offenses.
All right. For Mr. Braxton.
Yes, Your Honor. 30-year-old lifelong resident, 2 children. He was forthcoming with us about his prior cases. He does have the case pending in front of Judge Giles right now, in which we're here for today. He already got a $10,000 cash and surety bond for a non-assaultive allegation for stealing Red Bull and Monster, regardless of how many cans it was. It was non-assaultive, Your Honor, in which no one was harmed. We have
I hate to
thorough
interrupt
discussion
you,
with my client.
Mr. Byrd, hate to interrupt you. It wasn't $10,000 cash, it was $10 cash surety.
Oh, $10. Okay, I thought you said 10,000.
Yeah, it was subject to that MCL 765.6A where the court is mandated to set a cash bond. So I set it at $10.
Right. No, I thought you said 10,000, and that's my apology, Your Honor, and my apology on Judge Williams for stating that. So we're just asking to keep this bond accordingly at a low bond at $10 in this matter. Allow him to show up. I haven't heard that he had a tether on, and maybe we could try a tether in this matter, Your Honor.
Wait. I'm sorry. I'm confused now. And Judge Boyd, you got to help me out. Which case is before me? I thought it was Judge Giles's case.
It is.
Judge Giles's felony case.
All right, so that's
looks
24055733301. Bond set at 30,000 cash right now. Is that right?
That's right. Yep.
correct.
Okay. Now, Mr. Bird, I'm assuming you're asking me to change that bondage. Is that right?
That's right, Your Honor.
Okay. Because you just said keep it as a low nominal bond. I don't think that's what you wanted. So I'll let you finish. Go ahead.
We actually asked for a personal bond on this matter, Your Honor. And that was my fault. I was speaking on this other case. I thought I heard 10,000 cash, in which the Honorable Judge Boyer said it at $10 cash. So that's my apologies. But we're gonna ask for personal bond in this matter. It's non-assaultive also, as the rest of his cases, regardless if it was a monster or fatal pop. No one was hurt, no one was harmed, and it was non-assaultive, Your Honor. So on this matter, we're asking for personal bond. He has a $10 bond to pay. That's going to be difficult for him to pay. And that's what we're going to be asking for, Your Honor.
1 second.
And Judge, while you're looking, Mr. Bird knows, I have a lot of respect for him. This does not have anything to do with assaultiveness or dangerousness. This is strictly flight. Cash bond being either for dangerousness or flight. We have that case out of Roseville. We now have 2 cases in 3060, this being the 3rd case, and this is a felony. And he's just failed to appear on at least 3 out of the 4. And the only reason why, the people think he hasn't failed to appear on the 4th one, he just got arraigned on it today.
Which is the one he was just arraigned on today?
The misdemeanor. The retail fraud.
Second retail fraud.
Correct.
044382.
Okay.
Yeah.
All right. I've had a chance to well, let me ask you this, Mr. Bird. What reason do you have, or does can you tell me why your client missed this court date before Judge Giles?
Our client indicated to us that he was at the Detroit Detention Center on February 27th, 2024, yeah.
Okay. And that is for Mr. Vincent, you can help me out with this one. This is for the retail fraud that was just arraigned. Is that why he missed? Because it was arraigned.
Well, I don't think that could have been, Judge, because now we're March 11th, and I mean, if he was being held 2/27, I don't know if I think defense counsel would be squawking if he had been held for 14, 15 days for this matter. So I can't give you the reason why, Judge. Nothing in the ROA talks about him being in the DDC. I have that Roseville case, but he just flat out didn't show up to that. Judge, I don't know. The failure to appear in that December case was February 12th. And then we have this failure to appear at exam the 27th. So
I tend to agree. I just want to make sure that,
yeah,
I was seeing this right. There's a lot going on.
Yeah.
There's an awful lot going on. And I don't have any reason to believe that Mr. Braxton was in the DDC at the time of Judge Giles's exam, which would indicate to me, there is some sort of flight risk. The reason that we're here today is because of another incident where the defendant was arrested in early March. But Mr. Bird, if I'm missing something, please help me out. But I don't see anything that would indicate that Mr. Braxton was in Mound at that time. So I'm inclined.
That's what. Sorry, Your Honor, I didn't mean to cut you off.
No, I started talking after I asked you a question. You go ahead.
That's what our client indicated to us, Your Honor. I'm just if we could try a tether. He hasn't been put on tether yet. That would be the least restrictive means in order to make him show up to court at this time, which I believe that could make him show up to court. And
You know,
that's what we're
at
gonna
this
ask.
point, I'm not inclined for any of that. I'm going to keep Judge Giles's bond where it's at. I do believe, based on the preponderance of evidence, there's a flight risk, and you know, I've got two new cases in 2024. I have a case in December of 2023. Another case that's before Judge Yancey in 2024. I'm just not convinced that a non-cash bond will ensure the defendant shows up. So I'm keeping the bond where it's at, setting bond intentionally unaffordable at 30,000 cash. Is
Okay.
there anything further from me?
No, I appreciate it, Judge. Thank you.
Nothing further, Your Honor.
All right, then that concludes the hearing. Good luck, Mr. Braxton.
Hold on, Mr. Braxton, for your dates. You'll have Mr. Braxton.
Oh, that's my fault. Sorry about that, Judge Boyer.
No problem. There'll be a bond redetermination hearing on Wednesday, March 13, in 2 days. And that's in front of Judge McConico. Further dates are probable cause conference, March 18th, and preliminary exam, March 25th, both in front of Judge Giles here in 36th District Court. All right, now you're all set, Mr. Braxton.
Thank you, Magistrate.